Well, let's take you now to one of our top stories, and this is the Senzo Meyiwa murder trial delayed to start today due to legal arguments being heard over whether to allow a documentary crew to continue filming the proceedings. Legal analyst Gaopalelwe Mathiba joins me now. Mr. Mathiba, good evening to you. Thank you so much for your time. Quite interesting to hear the legal arguments being made by the lawyers of the defense, who were essentially arguing that there should be a separation between what would be considered traditional media houses, news broadcasters, versus documentary makers, in this instance, 1010 Media House.
Well, thank you so much, Sis Kathy, for hosting me this evening, and greetings to your viewers at home. Yes, you are quite correct. What we have seen this morning in the Pretoria High Court in the Senzo Meyiwa trial is yet another stream of delay with the technicalities on that actually takes much time on that should be vested in focusing on the actual merits of this case. I mean, the witness stood 2 to 3 hours listening to twist and tense arguments that were purely on technicalities, because what the court had to grapple with really was whether or not Netflix affiliated company or crew constitute what we would call a media house. And that debate went on and on and on and on, with the defense attorney arguing that Netflix crew does not really, it cannot be given a status of a mainstream media house, and therefore it should not have been granted the permission to access the courts to film the proceedings. So we have then seen, with that proposition of the defense, then a certain master who was representing the Netflix affiliated group crew came and argued to say they have applied, just followed the same procedure that is there in the given court practice, to apply for permission as if they were a media. Now I'm using the phrase that Judge Maumela used to say the Netflix crew applied for permission to film the proceedings as if they were a media house, and I feel like that was a very, to some degree, was a shortcoming on the side of the judge, because I would assume and ask myself, why would the permission be granted if the identity of an entity is not or has not been properly established as to whether or not it's a media house that can be considered to be falling under mainstream media houses such as your Newzroom Afrika, such as your ENCA, such as your SABC. So I feel like the judge, in having granted the permission to that entity, was also, has some, to a certain extent, some degree of blameworthiness that has to be apportioned to him for having granted that permission without being sure that this is indeed a media house. Because he then comes to show that the judge himself was not sure of the identity of this entity. He then comes and then say the entity submitted an application for permission to film the proceedings, and the application came from the entity as if the entity was a media house. So I find that very problematic to say. But then if the judge himself was not sure of the entity being a media house in terms of the Broadcast Act of South Africa, how then did he proceed to grant them a permission to do so as if they were the established and the mainstream media houses that we know of?
All right.